of Russian interference, of the Steele dossier, of allegations of collusion by the Trump campaign, and that led him in part to Ukraine, and he got information that led him to various strands to pursue. And one of them became the issue of the Biden and Burisma incident. And he prepared a little package on it based on interview notes. In January 23rd and January 25th of 2019, months before Joe Biden had announced that he was going to run for the presidency, Rudy Giuliani was interviewing Shokin and Lutsenko and wrote down in the interview notes the stuff about the Biden and Burisma incident and the firing of Shokin. He put it all in a package. He delivered it to the State Department in March, still before Joe Biden said he was going to be running for president. That didn't happen until April 25th. It was all done, all put in a package, all delivered. And that's public now because that little package that he sent to the State Department was released. I think it was under a FOIA litigation, but it's been released publicly. And the notes that he took, his interview notes, are there publicly. So the timing dates back to when Rudy Giuliani was pursuing that, starting back in the fall of 2018. It takes him time to pursue leads. He was trying to get Shokin to come to this country to interview him. Couldn't get him a visa. Had to interview him by phone. Lutsenko was in New York, and he prepares this package. That's why there's that timing. And then there were public articles published about the Biden-Burisma affair. One of them was just mentioned in the question, a Washington Post article, July 22nd, 2019, specifically about it, about the firing of Shokin, 3 days before the July 25th telephone call. It was in the news. It was topical. Thank you.
Your counsel?
Chief Justice.
Senator from Michigan.
Chief Justice, on behalf of myself and Senator Cornyn, I sent a question to the desk for both House managers and the President's Counsel.
Thank you. The question from Senators Peters and Cornyn for both parties: how would the verdict in this trial alter the balance of power between the executive and legislative branches in the future? The President's Counsel goes first.
A verdict, a final judgment of acquittal, would be the best thing for our country and would send a great message that will actually help in our separation of powers. Here's why. As I've said repeatedly, and according to the standard articulated so well during the Clinton impeachment, what are we dealing with here? We're dealing with a purely partisan impeachment with bipartisan opposition, no crime, no violation of law in an election year. Okay? Never happened before. No investigation. No due process, nothing. And what they're telling you, I mean, we can talk all we want, and we will, but what are we talking about at the end of the day? We're talking about removing a president of the United States from a ballot in an election that's occurring in months. Who thinks that's a good idea? Particularly when you're dealing with a purely partisan impeachment that was warned about from the framers, okay? So the only appropriate result that won't damage our country horribly, maybe forever, but certainly for generations, is a verdict of acquittal. Here's the other point. Getting back to the question of witnesses. Mr. Schiff's up here, let's make a deal. How about we have the Chief Justice, and we have the greatest respect for the Chief Justice. Here's the problem. We're talking about critical constitutional rights that have been protected by the Supreme Court for our history. So what is he really saying? He's saying that the Senate, think about these questions, the Senate can decide about executive privilege by a vote, by a majority vote. If the Senate can decide, with the greatest respect, if the Senate can just decide there's no executive privilege, guess what? You're destroying executive privilege. Can the Senate decide the House's speech or debate protection? I mean, when we ask for documents from Mr. Schiff and his staff, and he says speech or debate, are you going to decide that? Is that how we're going to do this? Are we going to flip a coin? Is that going to be your next suggestion? We're talking about an election of the president. There are critical constitutional issues that will alter our balance of power for generations if we go down that road. Down this road is the path provided by the Democrats so wisely during the Clinton administration and an election. Thank you.
It may be different in the court than it is in this chamber and in the House, but when anybody begins the sentence with the phrase, "I have the greatest respect for," you have to look out for what follows. We trust the justice will make the right decision. The justice has, I think, conducted these proceedings in an eminently fair way. There is nothing in the Constitution that would preclude us from taking a week to hear from witnesses and allowing the Chief Justice to make those calls. And I would say also with respect to an argument counsel made about the Porteous impeachment trial, where yes, the Senate designated 12 senators to hear the witness testimony. The implication is you can't do that in an impeachment of the president. That's only half correct. The other half is you could do depositions in which only a couple members of the body need participate. And so it's a false argument to say or suggest that the whole body would need to conduct the whole of the depositions. So much as we would like live testimony, we've offered a compromise. But with respect to the question about what will this do to the balance of power, I would say this. As I mentioned earlier, our relationship with Ukraine will survive this debacle. But if we hold that a president can defy all subpoenas, can tie up the Congress endlessly with bad faith claims of privilege, claiming here one thing, claiming in court something else, it will eviscerate our oversight power. If the president is allowed to decide which subpoenas they will deign to consider valid and which they will deign to consider invalid, your oversight power, our oversight power is gone. That is an irrevocable change to the balance of power. And what's more, if we adopt their theory of the case, that a president can abuse his power, can do so by holding another country hostage, by withholding congressionally appropriated funds, can violate the law in doing so, as long as they think it's in their interest. Imagine what that will do to the balance of power. Article 2 will really mean what the president says it means, which is he can do whatever he wants. So yes, the stakes are big here. Article 2 goes to whether our oversight power, particularly in a case of investigating the president's own wrongdoing, continues to have any weight, whether the impeachment power itself is now a nullity.
Thank you, Mr. Manager.
Mr. Chief Justice.
The Senator from Florida.
I send a question to the desk on behalf of myself and Senators Capito and Scott of South Carolina, with all due respect.
Thank you. The question from Senators Rubio, Capito, Scott, and Scott of South Carolina is directed to both parties, and we begin with counsel for the House managers. The question reads, if I understand the manager's case, the president abused his power because he acted contrary to the advice of his advisors, but he is guilty of obstruction of Congress because he acted in accordance to the advice of his advisors.
That's not our argument at all. The president is impeached on Article 1 not because he acted contrary to the advice of his advisors. That's a red herring offered by the president's legal team. We're not saying that the president is not free to disregard the advice of his counsel. He is. He is entitled to disregard even really good advice. What he is not free to do is engage in corruption. What he's not free to do is to withhold military aid, not for a valid policy disagreement. They've conceded Rudy Giuliani was not doing policy. What is not permitted is for a president to withhold congressionally appropriated money for a corrupt purpose, to secure help, elicit foreign help, to cheat in an election. That is no policy disagreement. Now, are we arguing in Article 2 that he should be impeached for following his lawyer's advice? No, they were following his advice. His advice was fight all subpoenas. They were giving the legal window dressing to that. They were going to court and arguing one thing and coming before you and arguing another. He was not following their advice. They were following his. You can say a lot about Donald Trump, but he is not led around by the nose by his legal counsel. Ask Don McGahn about that. Don McGahn stood up to the president. And Bob Mueller, if we're going to talk about the Mueller report, found several instances, and this goes to the pattern of the president's misconduct, in which he sought to obstruct that investigation by including telling the president's lawyer that he should fire the special counsel and then that he should lie about that instruction.
Thank you, Mr. Manager.
Thank you, Mr. Chief Justice, members of the Senate. You're right. That's yet another way in which the House manager's theories of impeachment are incoherent and dangerous. With respect to Article 2, and again, I won't respond to the ad hominem attacks that keep coming. I will say, just for the record, that you're right, I haven't been elected to anything, but when I say with the greatest respect, I mean it. Article 2. The president's been impeached for exercising long-standing constitutional rights. He's looking out for constitutional rights in the face of a House process that violated all of them against all precedent. And he's looking out for future presidents and for the executive branch. How? If he had said, okay, fine, no rights, no counsel, no witnesses, no right to cross-examine. Here's everything you asked for. What sort of precedent would that set? That would irreparably damage the separation of powers. So again, all you need to look at are the articles of impeachment. The articles of impeachment do not allege a crime. They do not even allege a violation of law. They are purely partisan. They were opposed by Democrats in the House. It is in an election year. And they're here saying, instead of an election, let's confront very consequential constitutional issues that have never really been confronted. And let's do it in a week. Let's destroy executive privilege. Maybe let's destroy speech or debate privilege. And let me point out one other thing. It's not right to accuse somebody falsely of something and then say, unless you waive your constitutional rights, you're guilty. That's not right. We shouldn't accept that in this country. These are long-standing privileges. They've been respected for hundreds of years, and we should continue to respect them. Thank you.
Thank you, counsel. The senator from West Virginia.
Mr. Chief Justice, I send a question to the desk on behalf of myself for the President's counsel and the House managers.
Thank you. The question from Senator Manchin for both parties, and we'll begin with the President's counsel. Over the past 2 weeks, the White House counsel had detailed all the problems associated with the House's decision to move quickly through their impeachment proceedings. Why shouldn't this body heed their advice and slow down and at least allow the judge to rule in the McGahn case to give the members of this body an official opinion from the judiciary on Article 2?
Mr. Chief Justice, Senator, thank you for the question. And I think the key point here is the McGahn case is not going to directly resolve something related to the obstruction charges here. It's going to address a legal issue with respect to an assertion of absolute immunity for Don McGahn. There should be a decision from the D.C. Circuit sometime soon, but that will almost certainly go to the Supreme Court. I mean, if that immunity is being challenged and it's been relied upon by the executive for over 40 years, that's an issue destined for the Supreme Court. So the idea, it's not going to be just slow down here a little bit. This trial can't be held open pending the final resolution of that litigation. And that's an important point because this is something that Alexander Hamilton pointed out in Federalist number 65 when he was discussing who should be the body to try impeachments. And one consideration was potentially drawing in judges from various states to create a new body to try impeachments. And the rationale that Hamilton gave for that would be a bad idea is that there has to be a swift progression from an impeachment to the trial to a verdict to having it finished, precisely because this is where he talked about the persecution of an intemperate or designing majority in the House of Representatives. He recognized there could be partisan impeachments, and that accusation, that impeachment, shouldn't be hanging out there. There should be a swift trial to determine things finally. And that's why all of the preparation ought to be done in the House of Representatives to ensure that there's an investigation, there's a case put together, and if they're ready to impeach the President of the United States, they had better be finished, have everything buttoned down, and have their case ready. Because they can't have a trial of the President. Hamilton warned against that specifically, hanging over the country for months on end. And so to push off this trial, to say, well, we'll wait for litigation then at that point, that's a very dangerous idea. And that's not the way that the trial here should operate. It ought to be finished on the basis of the case that the House managers came ready to present. If they weren't ready to present a case that can win, there should be an acquittal. Thank you.
Thank you, counsel. We have another half of the presentation.
If we could, Senator, if we could pull up slide 37. This is what the district court had to say in the McGahn litigation now on appeal. Executive branch officials are not absolutely immune from compulsory congressional process, no matter how many times the executive branch has asserted as much over the years. That is consistent with the decision in the Myers case, where the court said clear precedent and persuasive policy reasons confirm that the executive cannot be the judge of its own privilege, and hence Ms. Myers is not entitled to absolute immunity. Let's look at what the court said on slide 38, where Judge Jackson said, stated simply, the primary takeaway from the past 250 years of recorded American history is that presidents are not kings. Compulsory appearance by dint of a subpoena is a legal construct, not a political one, and per the Constitution, no one is above the law. This is the district court saying, thou shalt appear, and this claim of absolute immunity is absolute nonsense. The court, now this is what the Justice Department is arguing in that case, if we could see slide 39. The committee lacks Article 3 standing to sue to enforce a congressional subpoena demanding testimony from an individual on matters related to his duties as an executive branch official. And so here we are, we're now in the Court of Appeals. The Justice Department is saying that you cannot enforce congressional subpoenas. And they're saying, well, let's continue to litigate the matter. Let's let this play out further. To what end? To what end? Yes, I suppose we could wait for a Court of Appeals decision, but of course they would say they're not satisfied with that court throwing out this idea either. Well, look, we've got a perfectly good justice right here that can make these decisions. Let's let him make the call. Let him make the call. Let's trust that he will be fair and impartial.
Thank you, Mr. Manager. The senator from South Carolina.
Thank you, sir. I sent a question to the desk on behalf of myself, Senators Hawley, Sass, and Barrassel.
Thank you. The question from Senators Scott of South Carolina, Hawley, Sass, and Barrasso is to the counsel for the president. During their presentation, the House managers referenced Chairman Gowdy and the House Benghazi investigation. The final report on Benghazi flatly says, quote, "The administration did not cooperate with the investigation," end quote. That committee fought for 2 years to access information and often had information requests ignored or denied. Yet this House investigation, after just 3 months, already supposedly justifies impeachment. Does President Trump owe more compliance than other presidents did?
Thank you, Mr. Chief Justice. Part of what we're seeing, I believe, is a kind of a twofold attack or approach. We just saw a citation to 2 district court opinions, as if the final arbiter of an issue of this magnitude is going to be the district court, or for that matter, the Court of Appeals. You're right. It's going to be the Supreme Court of the United States if it goes in that direction. Now, with regard to the question about the statement in the Benghazi report that the administration did not cooperate, the same was also true with Fast and Furious and the investigation there. And in that particular investigation, it reached such a significant point that members of the House determined that the then Attorney General of the United States should be held in contempt. Now, President Obama exercised executive privilege over documents and testimony related to Fast and Furious. The constitutional process was followed. Now, I'm not the one that makes the decision whether that was privileged or not privileged. If there was going to be a challenge, it would have been adjudicated. But the fact of the matter is, at least 10 times tonight, managership has said, we have complete confidence in the Chief Justice, ignoring the fact that it's not his call. And I mean that with all sincerity, since you're making fun of people that are saying with due respect. That's not the way it's set up. Now, you could agree to anything. Sure, you can negotiate that all the witnesses that'll be called will be the witnesses they requested. Or you can negotiate that, well, since they had 17 and we had none, we get 17 and they get 4. All kinds of things can be negotiated under their view. But this is brought to you by the managers who have an overwhelming case that they proved over and over again. That's what they say. They proved it. It's overwhelming. It's incredible. We were able to put it together in a record amount of time. And now we want you, the United States Senate, to start calling witnesses for our overwhelmingly proved case. I would just lay this down. If we're negotiating, why don't we just go to closing arguments, see what this body decides. But I respect the process. The process is we have 2 days of questioning. Tomorrow there'll be an argument on the motion. There'll be a decision on the motion, and we have to, that's the system that's in place. That's the system we should follow. But this idea that 2 district court judges have decided an issue of this magnitude, and that is now the determination, they wouldn't accept it if they were in our position. They would say, well, the district court decided, so that's going to be it. So I think when we have to look at what's really at stake, these are really significant issues. These are serious. I mean, the idea that executive privilege should just be waived or doesn't exist, that in your view, absolute immunity can't possibly exist. It's only been utilized for administrations for 50 years or more. Professor Dershowitz gave you the list of presidents that have put forward executive privilege, and a lot of his writings, he talks about it. But to say tonight, we're just going to, we'll just cut a deal. We'll do it in a week. We'll get some depositions, and that'll make everyone happy. Doesn't make the Constitution happy. Thank you.
Thank you, counsel.
Mr. Chief Justice.
The senator from Ohio.
I send a question to the desk on behalf of Senators Casey, Klobuchar, Warren, and Wyden for the House managers.
Thank you. The question for the House managers from Senator Brown and the other senators is as follows. Yesterday, you referenced how President Trump's perpetuating and propagating Russian conspiracy theories undercut our national security objectives. If acquitted in the Senate, what would prevent the president from continuing to side with Putin and other adversaries instead of our intelligence community and career diplomats? And what are the implications on our national security agenda if such behavior continues unchecked?
Mr. Chief Justice, Senators, thank you for the question. I've talked a lot tonight and throughout the last week about what's at stake here because, it's getting late into the night. We've been having this debate for several days now. There's a lot of discussion on the legal aspects of this. So I don't want to get in again to, the issues of our troops in Europe, the hot war that continues to happen right now as we're speaking in Ukraine. But I will reiterate the precedent that we set with regard to Russia and foreign adversaries. This idea that it's okay to continue to peddle in Russian propaganda and debunked conspiracy theories. Because counsel for the president would have you believe that this is a policy discussion, that we have not resolved this, that there's a lot of debate about this issue. And if that is indeed the case, if we concede that, then there are some witnesses that we can call on, including Ambassador Bolton, that could shed additional light on it. But the fact pattern that we're sitting at right now, what we're talking about right now, is 17 witnesses that were called in the House, none of whom had any indicia or had any data to provide that any of these theories were accurate. We have the entire intelligence and law enforcement community of the United States unanimously saying that there's no indication that Ukraine was involved in 2016 election, that it was Russia. And don't buy the red herring, by the way, that the counsel for the president has brought forth, this idea that it can only be Russia. They said earlier that we're claiming that it can only be Russia. That's not what we're saying. Nobody on this team has ever said it can only be Russia, because indeed we know, as many of these people in the chamber know well, that there's a lot of malactors out there, that there's a lot of countries out there that have the capability and the will and that regularly try to attack us in a variety of ways. What we are saying is with respect to this issue, that's before this body right now, is unanimously the law enforcement agencies of the United States and the intelligence communities of the United States have said that it was Russia that interfered in the 2016 elections and that there's no data that suggests Ukraine was involved. That's the issue. So the precedent, bringing it all the way around to the beginning of the question, the precedent is that all of our adversaries, including Vladimir Putin, will understand that they can play to the whims of one person, whether that be President Trump or some future president, Democrat or Republican. They can play to the whims and the interests and the personal political ambitions of one person and get that individual to propagate their propaganda, get them to undermine our own intelligence and law enforcement communities. That is a precedent that I don't think anybody here is willing and interested in sending, and that is truly what's at stake.
Thank you, Mr. Manager.
Mr. Chief Justice.
The senator from North Dakota.
I'm sending a question to the desk for myself, for Senator Bozeman,
Senator Wicker and Senator Capito.
Thank you. The question for counsel for the president from Senator Hoeven, Bozeman, Wicker, and Capito. House managers contend that they have an overwhelming case and that they have made their case in clear and convincing fashion. Doesn't that assertion directly contradict their request for more witnesses?
Mr. Chief Justice, Senators, thank you for the question. And I think it does directly contradict their claim now that they need more witnesses. They said for weeks that it was an overwhelming case. They came here and they've said 63 times that it's overwhelming or proved beyond a reasonable doubt. Manager Nadler said twice today that based on what they've already shown you, it's been proved beyond any doubt. All right? If that's their position, why do they need more witnesses or evidence? It's completely self-contradictory. And I'd like to address a couple of other points while I'm here and I have the time. And we've gone back and forth on this, and I don't know why I have to say it again. The House managers keep coming up here and saying and acting as if you mention Ukraine in connection with election interference, you even mention it, you're a pawn of Vladimir Putin, because only the Russians interfered in the election. And there's not any evidence in the record, they say, that the Ukrainians did anything. I read it before, I'll read it again. One of their star witnesses, Fiona Hill, said that some Ukrainian officials, quote, bet on Hillary Clinton winning the election, end quote. So it was, quote unquote, quite evident that they were trying to curry favor with the Clinton campaign, including by trying to collect information on Mr. Manafort and on other people as well. So that was Fiona Hill. There was also the evidence in the record from a Politico article in 2017 that listed a whole bunch of Ukrainian officials who had done things to try to help the Clinton campaign and the DNC and to harm the Trump campaign. In addition, two news organizations, both Politico and the Financial Times, did their own investigative reporting. And the Financial Times concluded that the opposition to President Trump led Kiev's wider political leadership to do something they would never have attempted before, to intervene, however indirectly, in a U.S. election. That's the Financial Times. So the idea that there is no evidence whatsoever of Ukrainians doing anything to interfere in any way is just not true. They come up here and say it again and again. It's just not true. The other thing I'd like to point out, Manager Schiff keeps suggesting that somehow we're coming here and saying one thing and the Department of Justice is saying something else in court about litigation. That's also not true. We've been very clear every time. The position of the Trump administration, like the Obama administration, is that when Congress sues in an Article III court to try to enforce a subpoena against an executive branch official, that is not a justiciable controversy, and there is not jurisdiction over it. The House managers in the House, though, take the position that they have that avenue open to them. So our position is when we go to court, we will resist jurisdiction in the court. But if the House managers want to proceed to impeachment, where they claim that they have an alternative mechanism available to them, our position is the Constitution requires incrementalism in conflicts between the branches. And that means that first there should be an accommodation process, and then Congress can consider other mechanisms at its disposal, such as contempt, or such as squeezing the president's policies by withholding appropriations, or other mechanisms to deal with that interbranch conflict. Or if they claim that they can sue in court, sue in court. But that impeachment is a measure of last resort. Now, earlier, Manager Schiff suggested that today in court, the Department of Justice went in and said, there's no jurisdiction. And when the judge said, well, if there's no jurisdiction to sue, then what can Congress do? And the DOJ, as he represented it, simply said, well, if they can't sue, then they can impeach, as if that was the direct answer, just go from, if you can't sue, the next step is impeachment. Now, that didn't seem right to me, because I didn't think that was what DOJ would be saying. And DOJ has put out a statement. I don't have a transcript of the hearing. They don't have a transcript ready yet, as far as I know. But DOJ said, and this is a quote from the statement, "The point we made in court is simply that Congress has numerous political tools it can use in battles with the executive branch. Appropriations, legislation, nominations, and potentially in some circumstances even impeachment. For example, it can hold up funding for the president's preferred programs, pass legislation he opposes, or refuse to confirm his nominees." And this is continuing their statement. "But it is absurd for Chairman Schiff to portray our mere description of the Constitution as somehow endorsing his rushed impeachment process."
So,
thank you.
Mr. Chief Justice.
Senator from Connecticut.
Thank you, Mr. Chief Justice. Mr. Chief Justice, I send a question to the desk for the House managers.
Thank you. The question from Senator Blumenthal to the House managers. On April 24, 2019, one day after the media reported that former Vice President Biden would formally enter the 2020 U.S. presidential race, the State Department executed President Trump's order to recall Ambassador Marie Yovanovitch, a well-regarded career diplomat and anti-corruption crusader. Why did President Trump want, in his words, to, quote, take her out, end quote?
Well, Mr. Giuliani has provided the answer to that question. He stated publicly that the reason they needed to get Ambassador Yovanovitch out of the way was that she was going to get in the way of these investigations that they wanted. This is the president's own lawyer's explanation for why they had to push out, why they had to smear Ambassador Yovanovitch. So the president's own lawyer gives us the answer. And that ought to tell us something, that in a couple of respects. One, that the president's own agent has said that she was an impediment to getting these investigations, this anti-corruption champion who's at an awards ceremony or a recognition ceremony for a Ukrainian anti-corruption fighter, a woman who had acid thrown in her face and who died a painful death after months. She's at that very ceremony acknowledging this other champion fighting corruption when she gets the word, "You need to come back on the next plane." Now, one of the reasons the Ukrainians knew they had to deal with Rudy Giuliani is that Rudy Giuliani was trying to get this ambassador replaced, and you know, he succeeded. He succeeded. And that sent a message to the Ukrainians that if Rudy Giuliani had the juice with the President of the United States, had the power with the President of the United States to recall an ambassador from her post, this was somebody that not only had the ear of the president, that could make things happen. So the short answer is Rudy Giuliani tells us why she had to go. Now, why they had to smear her, why the president couldn't simply recall her, that's harder to explain. But the reason they wanted her out of the way is they wanted to make these investigations go forward, and they knew someone there fighting corruption was getting in the way of that. Now, I want to say with respect to some of the arguments against having the testimony of John Bolton, these are some of the former national security advisors who have been called to hearings and depositions. Zbigniew Brzezinski, the national security advisor for President Carter, provided 8 hours of public hearing testimony and additional deposition testimony before the Senate Judiciary Committee subcommittee to investigate individuals regarding the interests of foreign governments. Admiral Poindexter testified, provided over 25 hours of public hearing testimony and 20 hours of deposition testimony before the House Select Committee to investigate covert arms transactions with Iran. Robert McFarland, former National Security Advisor for President Ronald Reagan, provided over 20 hours of public hearing testimony and 3 additional hours of deposition testimony. Samuel Berger, National Security Advisor for President Clinton, provided 2 hours of public hearing testimony before the Senate Committee on Governmental Affairs. Its inquiry into campaign finance practices. Condoleezza Rice, National Security Advisor for President George W. Bush, 3 hours of public testimony, additional closed session testimony. Susan Rice provided closed session testimony to the House Select Committee on how the Obama administration handled identification of U.S. citizens and U.S. intelligence reports. There is ample precedent where it is necessary to have testimony of national security advisors. Now, you saw, I think, the President's counsel dancing on the head of a pin and trying to explain why they're before you arguing we can't have these people come here, the House should sue in court, and why they're in court saying the court can't hear it. And I have to say I have great understanding for the difficulty of that position. I wouldn't want to be in the position of having to advocate that argument. But it goes to the demonstration of bad faith here. How can you be before this body saying you got to go to court, the House was derelict because it didn't go to court, and go to the same court and say the House shouldn't be here? How do you do that? Now they say, well, the House is in court, so the House must think it's okay, even though we don't think so, and we're arguing that, and we'll take it all the way up to the Supreme Court if we have to. We don't think that's an adequate remedy. That's the whole problem. When you have bad faith invocation of privilege, when you have in fact, assertion of privilege, when you have a president who wants to continue to cover up his wrongdoing indefinitely, a president who is trying to get foreign help in the very next election, that process of going endlessly up and down the courts with a duplicitous counsel for the president arguing in one place you can do it and the other place you can't, shows the flaw with a precedent that Congress must exhaust all remedies before it can insist on answers with the ultimate remedy of impeachment.
The majority leader is recognized.
Mr. Chief Justice, I suggest we take a 5-minute break.
Without objection, so ordered.
Mr. Chief Justice.
The senator from Iowa.
Mr. Chief Justice, I send a question to the desk for myself and Senator Lankford.
Thank you. The question from Senator Ernst and Langford is for the counsel for the president. Members of the House Permanent Select Committee on Intelligence, of which Manager Schiff sits as chairman, conducted a number of depositions related to this impeachment inquiry. One of the individuals deposed was Intelligence Community Inspector General Michael Atkinson. Has the White House been provided a copy of this deposition transcript? Do you believe this transcript would be helpful? If so, why?
Mr. Chief Justice and Senator, thank you for that question. We have not been provided that transcript. My understanding is that the Inspector General for the Intelligence Community, Mr. Atkinson, testified in executive session, and HPSI has retained that transcript in executive session, and was not transmitted to the House Judiciary Committee, and therefore, under the terms of House Resolution 660, was not turned over to the White House counsel, so we have not seen it. I just want to clarify, we don't think there's any need to start getting into more evidence or witnesses, but if one were to start going down that road, I think that that transcript could be relevant, because my understanding from public reports is that there were questions asked of the Inspector General about his interactions with the whistleblower. And there was some question in public reports about whether the whistleblower was entirely truthful with the Inspector General on forms that were filled out, and whether or not, certain representations were made about whether or not there had been any contact with Congress, and that then ties into the contact that the whistleblower apparently had with the staff of the committee, which we also don't know about. So if we were to go down the road, we don't think it's necessary. We think that these articles of impeachment should be rejected. But if one were to go down the road of any more evidence or witnesses, it would certainly be relevant to find out what the Inspector General of the intelligence community had to say about the whistleblower, along with the other issues that we've mentioned about whistleblower's bias, motivation, what were his connections with the whole situation of the Bidens, and apparently if he worked with Vice President Biden, he worked on Ukraine issues according to public reports. How does that all tie in? All of those things would become relevant in that event. Thank you.
Thank you, counsel.
Mr. Chief Justice.
The senator from Alabama.
Thank you, Mr. Chief Justice. I send a question to the desk on behalf of myself, Senators Manchin and Senator Sinema.
Thank you. The question from Senators Jones, Manchin, and Sinema is directed to the House managers. So much of the questions and answers, as well as the presentations, have focused on the completeness of the House record. Should the House have initiated a formal accommodations process with the administration to negotiate for documents and witnesses after the passage of House Resolution 660? And regardless of whether the House record is sufficient or insufficient to find the president guilty or not guilty, what duty, if any, does the Senate owe to the American public to ensure that all relevant facts are made known in this trial and not at some point in the future?
Senators, thank you for the question. It was apparent from the very beginning when the president announced that they would fight all subpoenas, when the White House counsel issued its October 8th diatribe saying they would not participate in the inquiry, that they were not interested in any accommodation. We tried to get Don McGahn to testify. We tried that route. We've been trying that route for 9 months now. We tried for quite some time before we took that matter to court with absolutely no success. And I think what we've seen is there was no desire on the part of the president to reach any accommodation. Quite the contrary, the president was adamant that they were going to fight in every single way. Now, if they had an interest in accommodation, we wouldn't be before you without a single document. There would have been hundreds and hundreds of documents provided. We would have entered an accommodation process over narrow claims of privilege as to this sentence or that sentence. They would have had to make a particularized claim that we could have negotiated over. But of course, they did none of that. They said your subpoenas are invalid. You have to depart from the bipartisan rules of how you conduct your depositions. Essentially, our idea of accommodation is you have to do it our way or the highway. And the president's instructions, the president's marching orders were go pound sand. Now, what is the Senate's responsibility in the context of a House impeachment for which there was such blanket obstruction? And bear in mind, if you compare this to the Nixon impeachment, Richard Nixon told his people to cooperate, provided documents to the Congress. Yes, there were some that were withheld, and that led to litigation, and the president lost that litigation. But the circumstances here are very different. Frankly, the president could have made this a difficult case, but didn't, because of the wholesale nature of the obstruction. Now, in terms of the Senate responsibility, the Constitution says the Senate shall have the sole power to try all impeachments. When sitting for that purpose, they shall be on oath or affirmation. And so you have the sole power. That expression is used, I believe, only twice in the Constitution. One when it tells the House that we have the sole power to conduct an impeachment proceeding, and again, the process we used, and they can repeat this as often as they like, is the same process used in the Clinton and Nixon impeachments. And I'm sure Clinton and Nixon thought that was unfair, but nonetheless, we use the same process. But here, you have the sole power to try the case. And if you decide that 1 week is not too long in the interest of a fair trial to have depositions of key witnesses, that is for you to decide. You get to decide how to try the case. And so if you decide that you have confidence in the Chief Justice of the Supreme Court to make decisions about materiality and relevance and privilege and make those line-by-line redactions if they're warranted, if you decide you trust the Chief Justice to decide whether privilege is being applied properly or improperly to conceal crime or fraud or for legitimate national security purpose, you have the sole power to make that happen. That is within every bit within your right. And we would urge you to do so. Now, counsel for the president says the Constitution doesn't require that. The Constitution doesn't prohibit that. It gives you the sole power to try this case. And under your sole power, you can say, we've made a decision. We're going to give the parties 1 week. We're going to let the Chief Justice make a fair determination of who's pertinent and who's not. We're not going to let the House decide who the president's witnesses are. We're not going to let the president decide who the House witnesses are. We're going to let them both submit their top priorities, and we're going to let the Chief Justice decide who's material and who's not. That is fully within your power. And so, in sum and substance, there's no evidence of an intention, a willingness in any way, shape, or form to accommodate in the House. If there was, we wouldn't be here. Instead, there was, we will fight all subpoenas, and under Article 2, I can do whatever I want. And now we're here. And they make the astounding claim, if their case is so good, let them try it without witnesses. That wouldn't fly before any judge in America. And it shouldn't fly here either.
Thank you, Mr. Manager.
Mr. Justice.
I'm sorry. Yes, the senator from Tennessee.
I send to the desk a question on behalf of myself and Senators Lee and Johnson.
Thank you. The question from Senator Blackburn and Senators Lee and Johnson is for counsel for the President. What was the date of the first contact between any member of the House Intelligence Committee staff and the whistleblower regarding the information that resulted in the complaint? How many times have House Intelligence Committee members or staff communicated in any form with the whistleblower since that first date of contact?
Mr. Chief Justice, Senator, thank you for that question. The answer is we don't know. Nobody knows. We don't know when the first contact was. We don't know how many contacts there were. We don't know what the substance of the contact was. That all remains shrouded in some secrecy. And as I said a moment ago, we think that the way this case has been presented, this body should simply acquit. There's no need to get more evidence to probe into that. But if we were to go down the road of any evidence or witnesses, then those are certainly relevant questions and relevant things to know about, to understand what those contacts were, what the whistleblower's motivation was, what the connection between the whistleblower and any staffers and how that played any role in the formulation of the complaint, that it all be relevant to understand how this whole process began. Now, I do want to mention something else while I have the moment in response to some things that Manager Schiff said. Again, the House managers come up and seems like they keep saying the same thing and we keep pointing to actual evidence and letters that disprove what they're saying. They come up and say that the president said it's my way or the highway, blanket defiance, there's nothing you can do. And they say that, well, they would have accommodated if we were willing to participate in the accommodation process. The October 8th letter that the counsel for the president, who Mr. Schiff says acts in bad faith and called duplicitous here on the floor of the Senate, sent a letter on October 8th to Mr. Schiff and others explaining, quote, if the committees wish to return to the regular order of oversight requests, we stand ready to engage in that process as we have in the past in a manner consistent with well-established bipartisan constitutional protections and a respect for the separation of powers enshrined in our Constitution. That was followed up in an October 18th letter that I mentioned before, a letter that specified the defects in the subpoenas that had been issued, not blanket defiance, not simply we don't cooperate, specifying the legal errors in the subpoenas. And it concluded, quote, as I stated in my letter of October 8th, if the committees wish to return to the regular order of oversight requests, we stand ready to engage in that process as we have in the past in a manner consistent with well-established constitutional protections and a respect for the separation of powers enshrined in our Constitution. The president stood ready to engage in an accommodations process. If anyone said my way or the highway here, it was the House, because the House was determined that they wanted just to get their impeachment process done on the fastest track they could. They didn't want to do any accommodation. They didn't want to do any litigation. They didn't want anything to slow them down. They wanted to get it done as fast as they could so it was finished by Christmas. It was a partisan charade from the beginning. It resulted in a partisan impeachment with bipartisan opposition, and it's not something this chamber should condone.
Thank you, counsel.
Mr. Chief Justice.
The senator from Nevada.
I have a question for the desk for the House managers.
Thank you. question from Senator Rosen is for the House managers. During the president's phone call with Ambassador Sondland, he insisted there was no quid pro quo involving the exchange of aid and a White House meeting for an investigation. But he also said, according to Sondland, that the stalemate over aid will continue until President Zelensky announces the investigations. Isn't that the definition of the exact quid pro quo that the president claimed didn't exist?
The short answer is yes. That's exactly what a quid pro quo is. When someone says, I'm not going to ask you to do this, but then says, I'm going to ask you to do this, that's exactly what happened here. Sondland calls the president, and the first words out of his mouth are no quid pro quo. Now that's suspicious enough. When someone blurts out what we would find out is a false exculpatory, but then the president goes on nonetheless to say no quid pro quo. At the same time, Zelensky has got to go to the mic to announce these investigations. That's the implication, and he should want to do it. So no quid pro quo over the money, but Zelensky's got to go to the mic. And if you have any question about the accuracy of that, you should demand to see Ambassador Taylor's notes, Tim Morrison's notes, and of course, Sondland goes and tells Ukraine about this coupling of the money in order to get the investigations. And let me just, if I can, go through a little of the history of that. You've got Rudy Giuliani and others trying to make sure the Ukrainians make these statements in the run-up to that July phone call. This is the quid pro quo over the meeting. So they're trying to get the statement that they want. They're trying to get the announcement, the investigations. And around this time, prior to the call, the president puts a freeze on the military aid. And then you have that call, and the minute that Zelensky brings up the defense support and the desire to buy more javelins, that's when the president immediately goes to the favor he wants. So the Ukrainians at this point know that the White House meeting is conditioned on getting these investigations announced. But in that call, the minute military aid is brought up, the president pivots to the favor he wants of these investigations they already know about. Now, after that call, the Ukrainians quickly find out about the freeze in aid. According to the former deputy foreign minister, they found out within days. July 25th is the call. By the end of July, Ukraine finds out the aid is frozen. The deputy foreign minister is told by Andriy Yermak, keep this secret. We don't want this getting out. She had planned to come to Washington. They cancel her trip to Washington because they don't want this made public. And so in August, there's this effort to get the investigations announced. That's the only priority for the president and his men. So the Ukrainians know the aid is withheld. They know they can't get the meeting. They know what the president wants these investigations. And the Ukrainians, like the Americans, can add up 2 + 2 = 4. But if they had any question about that, Sondland removes all doubt on September 1st in Warsaw, when Sondland goes over after the Pence-Zelensky meeting. He goes over to Yermak and he says that until you announce these investigations, you're not getting this aid. He makes explicit what they already knew, that not just the meeting, but the aid itself was tied. And on September 7th, Sondland tells Zelensky directly, the aid is tied to your doing the investigations. And it's at that point, on September 7th, when Zelensky is told by Sondland directly of the quid pro quo, that Zelensky finally capitulates and says, all right, I'll make the announcement on CNN. And then the president is caught. The scheme is exposed. The president is forced to release the aid. And what does Zelensky do? He cancels the CNN interview because the money was forced to be released when the president got caught. But that's the chronology here. Let's make no mistake. Ukrainians are sophisticated actors. As one of the witnesses said, They found out very shortly after the hold. The Ukrainians had good tradecraft. They understood very quickly about this hold. And what would you expect when you're fighting a war and your ally is withholding military aid without explanation, and the only thing they tell you that they want from you are the announcement of these investigations? And if it wasn't clear enough, they hammer them over the head with it. They told Yermak on September 1st, you're not getting the money without announcing these investigations. They tell Zelensky himself on September 7th, you're not getting the money without these investigations. And finally, the resistance of this anti-corruption reformer, Zelensky, is broken down. He desperately needs the aid. Finally, the resistance is broken down. All right, I'll do it. He's going to go on CNN.
Thank you, Mr. Manager.
Mr. Chief
Senator
Justice.
from Kansas.
Thank you, Mr. Chief Justice. I have a message to be sent to the desk, a question, and it's on my behalf, on the behalf of Senator Rubio, Senator Crapo, and Senator Risch.
Thank you. The question from Senator Moran, Crapo, and Risch reads as follows. Impeachment for the Counsel for the President. Impeachment and removal are dramatic and consequential responses to presidential conduct, especially in an election year with a highly divided citizenry. Yet checks and balances is an important constitutional principle. Does the Congress have other means, such as appropriations, confirmations, and oversight hearings, less damaging to our nation?
Mr. Chief Justice, Senators, thank you for the question. And yes, Congress has a lot of incremental steps, a lot of means short of impeachment to address friction or conflicts with the executive branch. And that was a point that I was making a moment ago with respect to what the Department of Justice had said in litigation today, where the absolute immunity for senior advisors, actually I think it's a different issue in that case, I beg your pardon, but in any event, there's a dispute in that case about information requests. And the point that DOJ was making there is the Constitution requires incremental steps where there's friction between the branches. As I mentioned the other day, friction between the branches and between Congress and the executive on information requests in particular is part of the constitutional design. It's been with us since the first administration. George Washington denied requests from Congress for information about the negotiation of the Jay Treaty. And so from the very beginning, there has been this friction leading to jockeying for position and accommodations and confrontation and leading to ways of working things out when Congress demands information from the executive and the executive asserts to protect the institutional authorities of the executive branch, the sphere where the executive can be able to keep information confidential. But the first step in response to that should be the accommodations process. And the courts have described that as constitutionally mandated, as something that actually furthers the constitutional scheme to have the branches negotiate and try to come to an arrangement that addresses the legitimate needs of both branches of the government. Part of that accommodations process, as the confrontation continues, can involve Congress exercising the levers of authority that it has under Article 1 to try to put pressure on the executive. So, for example, appropriations, not funding the policy priorities of a particular administration, or cutting funding on some policy priorities, or legislation, not passing legislation that the president favors, or passing other legislation that the president doesn't favor. Or the Senate has the power not to approve nominees. And as I'm sure many of you well know, holding up nominees in committee can be effective in some points in putting pressure on an administration to get particular policies kicked loose, things accomplished in a particular department or agency. All of these elements of the interplay of the branches of government, that's part of the constitutional design. But impeachment is the very last resort for the very most serious conflict where there is no other way to resolve it. So there are all of these multiple intermediate steps, and they all should be used. They all should be exercised in an incremental fashion. And that's exactly what didn't happen in this case. There was no attempt at the accommodations. There was no attempt even to respond to the legal issues, the legal defects that the counsel for the president and the departments and agencies pointed out in each of the subpoenas that were issued by the House committees. And even the issue of agency counsel, there was no attempt to try to negotiate on that. And that's really something that in the past, even last April, with the House Committee on Oversight and Government Reform with Chairman Cummings, there was a dispute about that. And we wouldn't allow a witness to go without agency counsel. And then we had a meeting with Chairman Cummings, and it got worked out. And it was turned into a transcribed interview, I think, and but agency counsel was permitted to be there. But the committee got the interview, they got to talk to the person, and they got the information they wanted. But the executive branch got to have agency counsel there to protect executive branch interests. And that's the way it's supposed to work. But there was no attempt at anything like that from the House in this case. Thank you.
Thank you, counsel. The senator from Massachusetts.
Thank you, Mr. Chief Justice. I send a question to the desk for the House managers.
Thank you. Senator Markey's question for the House managers reads as follows. It has recently been reported that the Russians have hacked the Ukrainian natural gas company Burisma, presumably looking for information on Hunter Biden. Our intelligence community has warned us that the Russians will be interfering in the 2020 election. If Donald Trump is acquitted of these pending charges, but is later found to have invited Russian or other foreign interference in our 2020 election, what recourse will there be for Congress under the Dershowitz standard for impeachment, which requires a president to have committed a statutory crime?
Senator, absolutely no recourse. No recourse whatsoever. If, in fact, it were later to be shown that not only did the Russians hack Burisma to try to get dirt on the Bidens and drip it out as they did in the 2016 election, let's say it were found that they did so at the request of the President of the United States. That in one of these meetings that the President had with Vladimir Putin, whose contents is unknown, that the President of the United States asked the President of Russia to hack Burisma because he couldn't get the Ukrainians to do what he wanted, so now he was turning to the Russians to do it. Under the Dershowitz theory of the case, under the President's theory of the case, that's perfectly fine. But that's not how bad it is, because it goes further than that. If the President went further and said to Putin in that secret meeting, I want you to hack Burisma, I couldn't get the Ukrainians to do it, and I'll tell you what, if you hack Burisma and you get me some good stuff, then I'm going to stop sending money to Ukraine. And I'll go a step further. I'm going to stop sending money to Ukraine so that they can't fight you in Donbass. And what's more, those sanctions that we imposed on you for your intervention on my behalf in the last election, I'm going to make those go away. I'm going to simply refuse to enforce them. I'm going to call it a policy difference. That's perfectly fine under their standard. That's not an abuse of power. You can't say that's criminal. Yeah, it's akin to crime, or maybe it's not, but that's what an acquittal here means. It means that the president is free to engage in all the rest of that conduct, and it's perfectly fine. And what's the remedy that my colleagues representing the president say that you have to that abuse? Well, you can hold up a nominee. That seems wholly out of scale with the magnitude of the problem. That process of appropriations or nominations is not sufficient for a chief executive officer of the United States who will betray the national security for his own personal interest. He got on the phone with Zelensky asking for this favor the day after Bob Mueller testifies. What do you think he will be capable of doing the day after he's acquitted here? The day after he feels I dodged another bullet. I really am beyond the reach of the law. My attorney general says I can't be indicted, I can't even be investigated. He closed the investigation into this matter before he even opened it. And I can't be impeached either. I got the best of both worlds. I got Bill Barr saying I can't be investigated, I can't be prosecuted. I can be impeached, however. That's what Bill Barr says, but I've got other lawyers that say I can't be impeached. That's a recipe for a president who is above the law. That only is not required by the Constitution, quite the contrary. The founders knew, coming from a monarchy, that if they were going to give extraordinary powers to their new executive, they needed an extraordinary constraint. They needed a constraint commensurate with the evil which they sought to contain. That remedy is not holding up a nomination. The remedy they gave for an executive that would abuse their power and endanger the country, that would endanger the integrity of our elections, was the power of impeachment. As one of the experts said in the House, if this conduct isn't an impeachable offense, then nothing is.
Thank you, Mr. Manager.
Mr. Chief Justice.
The senator from South Carolina.
I send a question to the desk on behalf of myself and Senators Alexander, Cruz, Portman, Toomey, Sullivan, and Murkowski to the Council for the President.
Thank you. The question from Senator Graham and the other senators is for the Counsel for the President. Assuming for argument's sake that Bolton were to testify in the light most favorable to the allegations contained in the articles of impeachment, isn't it true that the allegations still would not rise to the level of an impeachable offense, and that, therefore, for this and other reasons, his testimony would add nothing to this case?
Mr. Chief Justice, Senators, thank you for the question. Let me start by just making very clear that there was no quid pro quo. There was no, and there is no evidence to show that, there was not that sort of linkage that the House managers have suggested. But let me answer the question directly, which I understand to be, assuming for the sake of argument that Ambassador Bolton would come and testify the way the New York Times article alleges, the way his book describes the conversation, then it is correct that even if that happened, even if he gave that testimony, the articles of impeachment still wouldn't rise to an impeachable offense. And that's for at least two reasons. Let me explain that. The first is, on their face, the articles of impeachment, as they've been laid out by the House managers, even if you take everything that's alleged in them, they don't, as a matter of law, rise to the level of an impeachable offense. Because even the House managers haven't characterized them as involving a crime. So that's one level of the answer, that an impeachable offense would require a crime. Even going beyond that to a second level, the theory of abuse of power that they've alleged, put aside whether or not it's a crime, the theory of abuse of power that they have asserted is not something that conforms with the constitutional standard of high crimes and misdemeanors. It depends entirely on subjective intent, and it is subjective intent alone. And as Professor Dershowitz explained, and as I've explained, and I don't mean in the more radical portion of his explanation of his theory. I mean just in terms of what is high crimes and misdemeanors. He explained that something that is based entirely on subjective intent is equivalent to maladministration. It's equivalent to exactly the standard that the framers rejected because it's completely malleable. It doesn't define any real standard for an offense. It allows you to take any conduct that on its face is perfectly permissible, and on the basis of your projection of a disagreement with that conduct, a disagreement with the reasons for it, to attribute a bad motive, to try to say there's a bad subjective motive for doing that and we'll make it impeachable. That doesn't conform to the constitutional standard. So, at the common law, they would call the reaction to a charge like this a demur. You demur and simply say, even if everything you say is true, that's not an impeachable offense under the law. And that is an appropriate response here. Even if everything you allege is true, even if John Bolton would say it's true, that is not an impeachable offense under the constitutional standard, because the way you've tried to define the constitutional standard, this theory of abuse of power, is far too malleable. It goes purely to subjective intent, and it can't be relied upon. Then the third level of my answer is this. We've demonstrated that there is a legitimate public policy interest in both of the matters that were raised on that telephone call, the 2016 election interference and the Biden-Burisma affair. Because there is a legitimate public policy interest in both of those issues, even if it were true that there was some connection, even if it were true that the president had suggested or thought that, well, maybe I should hold up this aid until they do something, that's perfectly permissible where there is that legitimate public policy interest. It's just the same as if there is an investigation going on, the president wants a foreign country to provide some assistance. It's a legitimate foreign policy interest to get that assistance. It's legitimate to use the levers of foreign policy to secure that assistance. So because there is a legitimate public policy interest in both of those issues, and I think we've demonstrated that clearly, it would be permissible for there to be that linkage. But again, I'll close with where I began, which is there was no such linkage here. I just want to make that clear. But taking for the sake of argument the question as phrased, even if Ambassador Bolton would testify to that, even if you assumed it would true, there is no impeachable offense stated in the Articles of Impeachment. Thank you.
Thank you, Counsel. The Senator from Illinois. Thank you. Question from Senator Durbin for the House managers. Would you please respond to the answer that was just given by the President's counsel?
Senators, it's been a long couple days, so let me be blunt about where I think we are. I think we all know what happened here. I think we all understand what the President did here. I don't think there's really much question at this point about why the military aid was withheld or why President Zelensky couldn't get in the door of the Oval Office. I don't think there's any confusion about why he wanted Joe Biden investigated or why he was pushing the CrowdStrike conspiracy theory. I don't think there's really much question about that, and I don't think there's any question about what we could expect if and when John Bolton testifies, although the details of which we certainly don't know. I don't think there's really much question about that. But what's extraordinary is, although they can claim that this was a radical mistake or notion of Professor Dershowitz that they seem to be distancing themselves from right now, I guess they're accusing Dershowitz now of some maladministration in his argument of the defense. They're still embracing that idea. Because what they just told you, admittedly in outline of A, B, and C, they just told you is accept everything the House said, except The president withheld the military aid to coerce Ukraine into helping him cheat in the election, accept that these investigations are a sham, accept that he obstructed all subpoenas and witnesses, accept all of that. Too bad. There's nothing you can do. That's not impeachable. A president of the United States, this is now where we've come to in this moment of our history. The president of the United States can withhold hundreds of millions of dollars in aid that we appropriated, can do so in violation of the law, can do so to coerce an ally in order to help him cheat in an election, and you can't do anything about it except hold up a nomination. That's non-impeachable. They can abuse their power all they want. The president, this president, next president can abuse their power all they want in the furtherance of their reelection as long, here's the limiting principle, as long as they think their reelection is in the national interest. Well, that's quite a constraint. That's where we've come now after 2.5 centuries of our history. I think our founders would be aghast that anyone would make that argument on the floor of the Senate. I think they'd be aghast. You know, having come out of a monarchy, having, literally risked their lives, having taken this great gamble that people could be entrusted to run their own government and choose their own leaders, recognizing that we are not angels, setting up a system that would have ambition counter ambition, that we would so willingly abdicate that responsibility and say that a chief executive now has the full power to coerce our ally, a foreign power, to intervene in our election because they think it's in the national interest that they get reelected. Is that really what we think the founders would have condoned? Or do we think that this is precisely the kind and character of conduct that they provided a remedy for? I think we know the answer to that. They wrote a beautiful constitution. They understood a lot about human nature. They understood, as we do, that absolute power corrupts absolutely. And they provided a constraint. But it will only be as good and as strong as the men and women of this institution's willingness to uphold it, to not look away from the truth. The truth is staring us in the eyes. We know why they don't want John Bolton to testify. It's not because we don't really know what happened here. They just don't want the American people to hear it in all of its ugly, graphic detail. They don't want the president's national security advisor on live TV or even a non-live deposition to say, I talked with the president and he told me in no uncertain terms, John.
Thank you, Mr. Manager.
To be continued.
The senator from Georgia.
Question to the desk on behalf of myself and Senators Hawley, Cruz, Perdue, Gardner, Lankford, Hoeven, Scott of Florida, Portman, and Fisher.
Thank you. Excuse me. The question from Senator Loeffler and the other senators is for the counsel for the president. As reported by Politico, quote, in January 1999, then Senator Joe Biden argued strongly against deposing additional witnesses or seeking new evidence in a memo sent to fellow Democrats ahead of, of Bill Clinton's impeachment trial, end quote. Politico reports that Senator Schumer agreed with Biden. Why should the Biden rule not apply here?
Mr. Chief Justice, members of the Senate, in a memorandum dated January 5th, 1999, that is captioned Arguments in Support of Summary Impeachment Trial, Senator Biden discussed some history first regarding two Senate impeachment proceedings that were put forward in the Senate that were summarily decided. And this is what he said. These two cases demonstrate that the Senate may dismiss articles of impeachment without holding a full trial or taking any evidence. Put another way, the Constitution does not, impose on the Senate the duty to hold a trial. In fact, the Senate need not hold a trial even though the House wishes to present evidence and hold a full trial and the elements of jurisdiction are present. He went on to say, in a number of previous impeachment trials, the Senate has reached the judgment that its constitutional role as sole trier of impeachment does not require it to take new evidence or hear live witness testimony. This follows from the Senate's considerations for motions for summary disposition in at least three trials, and it listed the three trials of Judges Ritter, Claiborne, and Nixon. In each, the Senate considered a motion for summary disposition on the merits. In no case did the Senate decline to consider a motion for summary disposition as beyond the Senate's authority or forbidden by the Constitution. The framers did not mean that this political process was to be a partisan process. Instead, they meant it to be political in the higher sense. The process was to be conducted in the way that would best secure the public interest, or in their phrase, the general welfare. That was the Biden doctrine of impeachment proceedings. Now, some members in this chamber agreed with that. Some members that serve as managers also agreed with that. But now the rules are different. The rules are different because Manager Schiff just moments ago did what he's now famous for and created a conversation purportedly from the President of the United States regarding Russia hacking of Burisma. And he does the same thing he did when he started his hearings. So this is a common practice. But if we want to look at common practice and common procedures, the Biden rule is one. I'd like to address something else, because we've heard it time and time again about two judges have decided this issue of executive privilege. I want to address two things very quickly. My very first case at the Supreme Court of the United States, and it was a long time ago, over 30 years ago, 33 years ago. My client lost in the district court. They said, well, we'll appeal to the Ninth Circuit Court of Appeals. Went to the Ninth Circuit Court of Appeals, was not so successful. We didn't win there either. My client said, well, what do? I said, well, we have one option. We could file a petition for certiorari to the Supreme Court of the United States. Chances are they're not going to take the case. But at this point, it's an important issue to you, so why don't we proceed? My client agreed to proceed. A petition for certiorari was granted, and the court reversed 9-0 the Court of Appeals and the district court. And that's why you continue to utilize courts when appropriate. That's why you do it. And you don't rely on what a district court judge says. And the last thing I want to say, they are asking you, as a Senate body, to waive executive privilege on the President of the United States. Now, I want to think about that for a moment. They are asking you to vote to determine, or have the Chief Justice in his individual capacity as presiding judge, vote to waive executive privilege as it relates to the President of the United States. And that is what they think is the appropriate role for this proceeding to continue. I think you should adopt the Biden rule. Thank you.
Thank you, counsel.
Mr. Chief Justice.
Yes, the senator from Colorado.
Thank you. I'd like to send a question to the desk on behalf of myself and Senator Warner.
Thank you. The question from Senators Bennett and Warner is to the House managers. Mr. Sekulow said that if the Senate votes for witnesses, he will call a long chain of witnesses that will greatly lengthen the trial. Isn't it true that the Senate will establish by majority vote which and how many witnesses there will be? Isn't it also true that prior impeachment trials in the Senate commonly have heard witnesses who did not testify in the House?
Thank you, Mr. Chief Justice. I thank the distinguished senators for their questions. Certainly is the case that all we are asking the Senate to do is to hold a full and fair trial, consistent with the Senate's responsibility. Article 1, Section 3 of this Constitution, the Senate shall have the sole power with respect to an impeachment trial. And this great institution has interpreted that during the 15 different impeachment trials that have taken place during our nation's history, that a full and fair trial means witnesses, because this institution, every time it's held a trial, has heard witnesses, all 15 times, including in several instances where there were witnesses who did not testify in the House, who testified in the Senate. Now, the point was raised earlier about Benghazi. And Trey Gowdy, he's a good man. I served with him. He's a very talented lawyer. I'm sure he's pleased, the distinguished gentleman from the Palmetto State, that his name has been brought into this proceeding. But Trey Gowdy, according to one of the questions, said that the administration didn't cooperate. The White House, in that instance, and the State Department turned over tens of thousands of documents pursuant to a House subpoena. That's cooperation. Several witnesses appeared voluntarily in Benghazi, including General David Petraeus, former CIA director, Susan Rice, who at the time was the National Security Advisor, Ben Rhodes, the Deputy National Security Advisor, Admiral Mike Mullen, former chairman of the Joint Chiefs of Staff, General Carter Ham, former commander of AFRICOM, Defense Secretary Leon Panetta, he also showed up. General Michael Flynn, former DIA director. Who else showed up? The former Secretary of State, Hillary Clinton. She testified publicly under oath for 11 hours. That's cooperation. What happened in this particular instance in the House? No documents, no witnesses, no information, no cooperation, no negotiation, no reasonable accommodation, blanket defiance. That's what resulted in the obstruction of Congress article. So all we're asking is for the Senate to hold a fair trial, consistent with past practice. And every single trial the Senate has held, the average number of witnesses is 33. We cannot normalize lawlessness. We cannot normalize corruption. We cannot normalize abuse of power. A fair trial. Lastly, of the witnesses that did testify, voluntarily showed up, what did they have to say? These were Trump administration witnesses. Ambassador Sondland, how did he characterize the shakedown scheme, the geopolitical shakedown at the heart of these allegations? Ambassador Sondland, quid pro quo. Ambassador Taylor, crazy. Dr. Fiona Hill, a domestic political errand. Lieutenant Colonel Vindman, improper. John Bolton, drug deal. What would the framers have said? The highest of high crimes against the Constitution.
Thank you, Mr. Manager.
I have a
The
question.
Senator from Utah.
I have a question to send to the desk.
Thank you. The question from Senator Romney is for both parties, and I believe the House Manager will go first. Good guess. Do you have any evidence that anyone was directed by President Trump to tell the Ukrainians that security assistance was being held upon the condition of an investigation into the Bidens?
Senator, the evidence that's currently in the record, there are two people who had direct conversations with the president about the conditioning of aid on the performance of the investigations. The first was Gordon Sondland, who on September 7th had a conversation with the president that thereafter he related to Tim Morrison as well as Ambassador Taylor. And in the conversation that Ambassador Sondland described at the time, he said the president on the one hand said no quid pro quo, but then went on to say that Zelensky has to announce these investigations and he should want to. So the president made the direct link to Ambassador Sondland. Ambassador Sondland then made the direct link, or had already made the direct link to Andrei Yermak, but after the conversation with the president, had a conversation with Zelensky himself and conveyed what he had been informed by the president that Zelensky was going to have to conduct these investigations. And that's when Zelensky made the commitment to go on CNN. So Ambassador Sondland has acknowledged the tie between the two. So did Mick Mulvaney. And I think that video is now etched in our minds for all of history. Try to walk that back as he may. He was quite adamant when he was asked about that. And the reporter even followed up when he said that part of the reason why they held up the aid was the desire for this investigation into 2016. And the reporter said, well, what you're saying is a quid pro quo. You don't get the money unless you do the investigation of the Democrats. And the chief of staff's answer was, we do it all the time. Get over it. So you have it from the president's own chief of staff. You have it from one of the three amigos, one of the president's point people. And bear in mind, Ambassador Sondland, of course, not a never-Trumper, $1 million donor to the Trump inaugural, someone the president deputized to have a significant part of the Ukraine portfolio, someone who, given that he's the EU ambassador, if this was about burden sharing, would have said this was about a burden sharing, but he didn't, of course. He said it was about the investigations. The third direct witness will be John Bolton, if we are allowed to bring him before you. But there already are witnesses and evidence in the record of people who spoke directly to the president about this, and to which the conditionality was made clear. After the conversation...
Mr. Chief Justice. Senator, thank you for your question. I believe the question was, is there any evidence that anyone told that President Trump had anyone tell the Ukrainians directly that the aid was linked? I believe that was the question. And the answer in the House record is no. And I described this on Saturday when I walked through at length, and so I'd refer back to that presentation, Ambassador Sondland and Senator Johnson. Ambassador Sondland indicated in approximately the September 9th timeframe, as we've all heard the statement, he asked the president, and the president said, I want nothing, I want nothing, I want no quid pro quo. And you've heard a lot from the House managers about go out to the microphones or he needs to do the right thing. But I believe the statement was he needs to do the right thing. He needs to do what he campaigned on. Even earlier, Senator Johnson, again, because Ambassador Sondland told Senator Johnson that there was a linkage. So Senator Johnson asked the president directly. And we know the answer to that. The president said, was there any when Senator Johnson asked if there was any connection between security assistance and investigations, the president answered, no way, I would never do that. Who told you that? And the answer was Sondland. And Ambassador Sondland had come to that presumption prior to speaking to the president. And we saw the montage from Ambassador Sondland about presumptions and assumptions and guessing and speculating and belief. So we also remember the montage in which Ambassador Sondland was asked, did anyone on the planet tell you that the aid was linked to the investigations? And his answer was no. So in the House record before us, there is no evidence that the president told anyone to tell the Ukrainians that the aid was linked. And in fact, the article from the Daily Beast yesterday, thank you, Mr. Chief Justice.
The senator from Oregon.
Mr. Chief Justice, I send a question to the desk for Senator Schatz, for Senator Carper, and for myself.
Thank you. The question is for the House managers from Senators Merkley, Schatz, and Carper. Yesterday, Alan Dershowitz stated that a president cannot be impeached for soliciting foreign interference in his re-election campaign if he thinks it's in the public interest. The president's counsel stated that the president cannot be prosecuted for committing a crime. And the president himself has said, quote, I have the right to do whatever I want as president, end quote. Aren't these views exactly what our framers warned about? An imperial president escaping accountability? If these arguments prevail, won't future presidents have the unchecked ability to use their office to manipulate future elections like corrupt foreign leaders in Russia and Venezuela?
Senator, thank you for the question, Senators. Before I address it, I just wanted to complete my answer to the last question. On September 7th, the president has a conversation with Gordon Sondland, and the president says, no quid pro quo, but Zelensky has got to go to the mic, and he should want to do so. This is in the context of whether the aid is being withheld in order to secure the investigations. After that call, on the same day, Sondland calls Zelensky, the president of Ukraine, and says, you're not going to get the money unless you do the investigations. So you've got the communication between the president and Sondland conveying the message to the Ukrainians in short succession. And so I think you see that the message the president gave to Sondland was in fact communicated immediately to the Ukrainians. And of course, Sondland went on to explain to Ambassador Taylor and to Tim Morrison that the president wanted Zelensky in a public box. And what was meant by that is he wanted to have to go out and announce publicly these investigations if he was going to get the money. Remember, Sondland explained that the president's a businessman, and before he gives away something, before he signs the check, he wants to get the deliverable. And Ambassador Taylor says, that doesn't make any sense. Ukraine doesn't owe him anything. So it was clear to everyone, including the Ukrainians, they weren't going to get the money unless they did the investigations that the president wanted. And that's the connection on September 7th makes it crystal clear. In terms of the Dershowitz argument, when coupled with a president who believes that under Article 2 he can do whatever he wants. Yes, I mean, this is a prescription of a president, not just an imperial president, but an absolute president with absolute power. Because if a president can take this action and extort one country, he can extort any country. If he can make a deal with the president of Venezuela or take an action antagonistic to what Congress has legislated with respect to that country, can violate the law in doing it to get help in his reelection. And I think that example that Senator King asked about is directly on point. There's no limiting principle here as long as the president thinks it's in the interest of his reelection. So yes, he can ask the Israeli prime minister to come to the United States and call his opponent an anti-Semite if he wants to get U.S. military aid. And that principle can be applied anywhere to anything, to the grave danger of the country. That is the logical extension, not just of what Professor Dershowitz said yesterday, but to what the President's Council said today. You can accept every fact in the articles. We still think it's fine and beyond the reach of the Constitution. The President can extort an ally by withholding military aid, can withhold meetings, can ask them to do sham investigations, even if you acknowledge the fact that they are sham. In fact, they don't even have to be done, they just have to be announced, and there's nothing Congress can do about it. Now that is a prescription for a president with no constraint.
Thank you, Mr. Manager.
Mr. Chief Justice.
The senator from Indiana.
I, along with Senator Lee, send to the desk a question for the President's Council.
Thank you. The question from Senators Braun and Lee is for the counsel for the president. Under Professor Dershowitz's theory, is what Joe Biden is alleged to have done potentially impeachable in contrast to what has been alleged against President Trump?
Mr. Chief Justice, Senators, thank you for the question. And I believe that under Professor Dershowitz's theory, remember, he tried to categorize things into three buckets. One is purely good motives. One is, well, you might have some motive for your personal political gain, as well as public interest motives for doing something or intent. And then there was the third bucket of purely private pecuniary gain. And he said, that's the one, if you're doing it for purely private pecuniary gain, that's a problem. And I think that would be the distinguishing factor in what is potentially present in the facts known about the Biden and Burisma incident, because the conflict of interest that would be apparent on the face of the facts that are known is that there would be a personal, family, financial interest in that situation. Vice President Biden is in charge of Ukraine policy. His son is sitting on the board of a company that is known for corruption. The public reports are that apparently the prosecutor general was investigating that company and its owner, the oligarch at the time. Then Vice President Biden has quite openly said that he leveraged $1 billion in U.S. loan guarantees to ensure that that particular prosecutor was fired at that time. One could put together fairly easily from those known facts the suggestion that there was a family financial benefit coming from the end of that investigation because it protected the position of the younger Biden on the board. And that would be a purely private pecuniary financial gain. That's the third bucket that Professor Dershowitz was describing, and the one that is necessarily problematic, where he said that's where there's going to be a problem. That's where you would have a crime and a potentially impeachable offense. So I think that would be the distinction there, that is one that, if all of those facts lined up under Professor Dershowitz's categorization of things, would be the problematic category. Thank you.
Thank you, counsel.
Mr. Chief Justice, on behalf of myself and Senator Cardin and Senator Van Hollen, I have a question for the House managers that I will submit to the desk.
Thank you. The question from Senator Klobuchar and the other senators. Yeah, it's this one. I'm sorry. This one's from Senator Cardin. I think this is the right question, and it is directed to the House managers. No, we don't have the question before us. From Senator Cardin. Thank you very much. The question from Senator Klobuchar is to the House managers. Could you please respond to the answer just given by the President's Counsel and provide any other comments the Senate would benefit from hearing before we adjourn for the evening?
Mr. Chief Justice, members of the Senate. What we've just heard from the House, from the President's Counsel, is the usual nonsense. There are only three, as we draw to a close tonight, there are only three things to remember. One, this is a trial. As a trial, as any 10-year-old knows, we should have witnesses. We are told we can't have witnesses because, after all, the House says we proved our case, as we have, and so why should we need witnesses? Well, that's like saying that in a bank robbery, the DA announces that he's proved his case. He's had all the witnesses. And then an eyewitness shows up, and he shouldn't be allowed to testify because, after all, the DA was sure he proved his case first. That's absurd. Any 10-year-old knows it's absurd. And that's the President's case against witnesses, that we've had enough. There's always more. There aren't too many more here, but the fact is, when there are witnesses to be asked, they should be asked. Second, there's only one real question in this trial. Everything else is a distraction. A three-card Monte game being played by the President's counsel. Distractions. Don't look at the real question. Look at everything else. Everything else irrelevant. Look at the whistleblower. Irrelevant. Look at the House procedures. Irrelevant. Look at Hunter Biden. Irrelevant. Look at whether President Obama's policy was as good as or better than President Trump's policy with respect to Ukraine. Irrelevant. Look at the Steele dossier. Irrelevant. There's only one relevant question. Did the president abuse his power by violating the law to withhold military aid from a foreign country, to extort that country into helping his re-election campaign by slandering his opponent? That's the only relevant question for this trial. The House managers have proved that question beyond any doubt. The one thing the President's Counsel got right was quoting me as saying it was beyond any doubt. It is indeed beyond any doubt. That's why all these distractions. That's why the President's people are telling you to avoid witnesses, because they are afraid of the witnesses. They know the witnesses. They know Mr. Bolton and others will only strengthen the case. And yes, we hear, well, if the House managers say the case is so strong, why do you need more witnesses? Because the truth can be bolstered. I yield back.
Thank you, Counsel. The Majority Leader is recognized.
Mr. Chief Justice, I ask unanimous consent that the trial adjourn until 1 p.m. Friday, January 31st.
Without objection, the trial is adjourned.